I'm Neil McLean. I'm a partner in our local government practice and head up our local government practice at Brodie's. I'm joined by my partner Lynne Marr today, who's an employment partner who works for a number of local authority clients. So I'll hand over to Lynne, who's going to take you through the session, and I'll be back at the end, or to surprise Lynne throughout with any questions that come through.
Okay, thanks very much, Neil. Yeah, so today's topic is SOSR, which is a good old acronym. We thought this would be a good session to do because I think over the last couple of years, what I've found is when I'm speaking to some of you in local authorities are quite complex employment situations where it's really hard to try and channel the situation into an identified route, so to speak. So it's quite hard to badge it as either a conduct issue or an attendance issue or a performance issue. There are lots of different things going on where, frankly, you might get to the point of just being quite exasperated with a particular employee, and you're trying to identify how you find your way out of it. And very often the answer is to use a material reason, which is a potentially fair reason for dismissal, one which people don't always automatically reach for. And if they do, they're not always quite sure how to use it and how to get to the position where they're securing a fair dismissal. So that's what I thought we would cover today. And you can see on the slide that this is broadly what we're going to cover. What is an SOSR reason for dismissing, the sorts of situations that might amount to an SOSR reason for dismissal, and then some of the rules around securing a fair dismissal. There are some sort of basic principles around that. And the sorts of things that come up in this context or might fall into this bucket, again, you can see on the slide, they tend to be around behavioural issues, breakdown in relationships, what are sometimes referred to in some of the case law as intransigent employees, conflicts between personality clashes, essentially, people who are raising multiple grievances, situations where the employer is very concerned that particular behaviours might present a reputational risk to the council. And it can also cover things like business changes, varying terms and conditions, things like where there's competition, third-party pressure, third-party requests. So quite a number of situations that might amount to an SOSR reason for dismissal. So if we just move on to the next slide, it's useful just to remind ourselves of the sort of basic statutory dismissal provisions, because that is the foundation of understanding how you might get yourself to a fair SOSR dismissal. Now, as you'll all know, there are 5 potentially fair reasons for dismissal under Section 98 of the Employment Rights Act. There's conduct, there's capability, which can be sickness, absence, or performance issues, redundancy, a breach of some form of statutory enactment where people can no longer do the job that they're in because they don't hold a qualification or a professional registration or something of that nature. And then we also have the SOSR, and the wording that you see on the slide is lifted from Section 98 of the Employment Rights Act. So you're looking at a substantial reason that exists, which is of a kind that will justify you dismissing the employee holding the position which the employee held. And it looks like it's a bit of a catch-all. Sometimes people treat it like that. They consider that if they can't fit it into any of the other potentially fair reasons for dismissal, they can rely on this as a bit of a different bucket. We'll just shove it in there and we'll call it an SOSR. That is a bit dangerous to do that, because you have to be able to be satisfied that there is a material reason which will justify the dismissal. So it's not just a catch-all for something that won't fit in any of the other categories, but at the same time, there's not really any more of a statutory definition other than it has to be substantial. And what that means is that whether you can rely on that as a potentially fair reason will really vary from case to case. But we have seen that we can distill some themes from the case law, which we can see on the next slide. If we just move on to that, we can see the sorts of categories that often are covered by SOSR. So we've got change management, which are things like, in the ordinary course, things like redundancy processes, or reorganisation, and the distinction between those. So reorganisations which are not redundancy might present you with a SOSR reason for dismissal. And then some of the ones that I've already covered on the first slide, so things like the serial grievers and behavioural issues, third-party pressures and the like. So if we just move on to the next slide. The one thing I'll say before I go on to this one is that, of course, once you've identified the potentially fair reason for dismissal, that's only the first hurdle. So even if you're satisfied that there is a material reason in existence that allows you to consider dismissing an employee, you've still got to be able to show that at the time that you dismiss for that reason, you have acted reasonably in treating it as a sufficient reason for dismissal. And that's the other part of the test, or getting to securing a fair dismissal. And we will come on to that towards the end of the slides, but you've got to also be able to follow a fair process too. As I say, we'll come back to that. So in relation to using SOSR where there's change management going on, you'll see the sorts of scenarios that might be covered here. And I might just start actually with the last 2 bullet points, which is the part-time work, the part-time roles becoming full-time, and the non-renewal of fixed-term contracts, because they are quite discrete issues which sometimes come up. You will often find people in part-time roles arguing in circumstances where there's perhaps just a greater volume of work, or you want to reorganize the way in which work is done, and there's a requirement for it to be done on a full-time basis. People in the part-time roles are arguing that they are in effect redundant. That is probably not a redundancy situation, because there is not a diminished requirement for work of a particular kind to be done. The volume of work to be done is the same, it just has to be done in a different way. And so if there is a requirement, which obviously there might be all sorts of other discrimination issues, flexible working requests, all the rest of it, which feed into this. But if that is ultimately something which can be justified, that's the sort of situation that won't be a redundancy, it's just a reorganization of the work. And if the employee won't do it or refuses to do it, and you end up in a dismissal situation, the reason for the dismissal is likely to be an SOSR reason for the dismissal. And similarly, with non-renewals of fixed-term contracts, you'll all be aware that when you don't renew a contract, which is a fixed-term one or a limited-term one, then that is a dismissal in law. And obviously, if somebody has more than 2 years service, you will also be looking for a potentially fair reason for not renewing that contract going forwards. And there's often a bit of a fine line between whether those circumstances amount to redundancy or whether they can be an SOSR. And there are quite a few instances where it will be an SOSR and not a redundancy. So if, for example, there's a very discrete reason for having the fixed term contract, for example, a maternity cover, or you're covering a period of sickness absence, or you've brought somebody in because another person has been seconded or put into an interim acting up role or something like that, then when that contract's not renewed, that will be an SOSR reason as well. Now, if we just move on to the next slide, just to re-emphasize this point that there is a bit of a fine line or a distinction to be drawn between redundancy and SOSR, and it can sometimes be difficult to draw that line. But as I've already said, you have to think here about the statutory test for redundancy, which is that there is a diminished requirement for workers to carry out work of a particular kind. And there will very often be circumstances, and I'm sure you've come across them, where the nature of the services just need to be reorganized to meet a particular demand, or to fulfill your statutory duties. And you might just be reorganizing the way in which particular work's done. There might be changes to grading structures, for example, as well. And all of that is probably going to mean that there's not actually a reduction in the particular work that needs done. You might just need different people to do it, or for it to be organized in a different way. And that is likely therefore to mean that there is not a redundancy. So even if you need less people to do it, if the volume of work is still there and you're reorganizing it or shifting it around, then that might also be an SOSR if it results in some people's employment being terminated. So sticking with the theme of business change, the other thing which commonly comes up, if we move on to the next slide, is around changing terms and conditions of employment. Now, this is something which up until relatively recently, I might have talked about how you would go about varying terms and conditions of employment. This is not something that is unusual or has been in the past unusual for local government. You just have to think about, things like equal pay, varying terms and conditions in that context, dismissal and re-engagement where people won't agree to changes to terms and conditions, to know that that is something that has been an issue in the past. And what we would ordinarily have been saying or what we do say to clients in those sets of circumstances is that if you are going to embark on a a project, if you like, to vary terms and conditions of employment, what you might be trying to do is to seek agreement to employees, their consent to that process, but that ultimately, if after having followed a fair consultation process, collective consultation processes, you're unable to get to agreement, you might be in the position where if you cannot get consent via one of the recognised routes, that what you might be doing is deciding to terminate and then to re-engage on new terms and conditions of employment. And that, of course, would also be an SOSR dismissal. The difficulty really with that now for those of you working in the public sector is that you have to comply with the Fair Work principles and the Fair Work Convention. And I'm sure you're all very familiar with the concept or the policy position of Scottish Government, which is that there should be no fire and rehire. So that's quite a firm directive that employers in the public sector, anybody accessing public funds or using public funds or getting awards of grants for public funds, should not be using the threat of dismissal and re-engagement to pressurise staff into accepting different terms and conditions of employment to what they are on. And if you look at the government guidance on this, there's quite a large chunk of guidance on this, where ultimately the Scottish Government recognises that actually adopting that approach towards changing terms and conditions is not in itself unlawful and isn't always going to be contrary to employment law. It also recognises that the vast majority of employers are good employers, and even if they are adopting that approach, will do so in a very collaborative way. They will consult with unions, they will consult with staff, and they will do it as a last resort. But nonetheless, the Scottish Government are saying, we don't really care about all that. If you are accessing public funds, we do expect you to commit to not using fire and rehire practices. And I would be interested, I appreciate this is a webinar, it's difficult to get your feedback, but I would be very interested to hear by way of comments, perhaps, if any of you have found yourself in a difficult situation where you are looking to get agreement on varying terms and conditions, and you've ended up stuck because historically you might ultimately, if you'd just not been able to get that consent, dismissed and relied on SOSR reasons as the potentially fair reason for dismissal, and hoped that you would be able to show that you'd followed a fair and reasonable process by consulting and taking on board what the unions were saying, for example, and securing as much agreement via the unions or individually as you possibly could. And it seems to me now that you could be in quite a difficult position whereby you're either stuck and just can't make the changes that you need to make, or in the alternative, that rather than offering new terms and conditions, you simply dismiss, which I'm sure can't really have been the intention of the Scottish Government, given that part of the Fair Work principles is also about security of employment. So it's quite a bit of a conundrum, I think, in the local government public sector context. So that's that one. We've got a few examples on the next couple of slides, just as some cases around change management, just to really emphasise how this is used, albeit that you might be struggling to use it as a reason in this context now. But the Sanford against Newcastle upon Tyne Hospitals NHS Foundation Trust case, this was a case where the trust undertook a reorganisation. It was doing a rebanding, and there were, for the most part, the employees were not disadvantaged. So 20 of them did accept the offer. They got 2 years pay protection. They were all generally quite happy. 2 employees were not happy and refused to agree the change. And in that context, the trust terminated the employment, having gone through the consultation process. It was found to be a fair dismissal. They offered them re-engagement on the lower band without pay protection in the end. So that was found to be a fair dismissal, but you can see immediately now in Scotland with the Fair Work principles, that might be a tricky position for an NHS trust in Scotland to get to. And on the next slide, we've got another example, Scott & Co against Andrew Richardson. This is not a local authority or public sector case, but just another example of SOSR being used in this context of changing terms and conditions. So the respondent in this case wanted to introduce shift working so that they could increase evening work. It's a debt recovery company. They felt that that would allow more face-to-face discussions to be happening in the evenings when the debtors were available. So that's what they wanted to do. It was really for business reasons. They sought to consult with the staff on that. The claimant refused to agree in this particular case to the change in the shifts because he felt that they were just simply cost-cutting measures and it was going to do him out of overtime. So he refused to accept the new shift system and the need for the change in his terms and in conditions. So when he was dismissed and offered employment on the new T's and C's and brought an unfair dismissal claim, the employer obviously argued that there was a real business reason, a need for the change, and that there was a material reason they just couldn't continue to employ him in that role. And in that case, the EAT went to the EAT, found that there was a sound commercial reason, and actually it was justified to rely on that as some other substantial reason dismissal. So a couple of little examples in that area. If we move on to the next one, this is, I think we probably start to move into areas where the SOSR really comes into its own and is perhaps more commonly being used. And one of the things that we do find very often when we're speaking to clients is they'll say, we want to dismiss this individual because there's been a breakdown of trust and confidence. And I suppose before we get into more of the cases and other examples of situations which might result in SOSR dismissals, I think it's just useful to pause and think about whether you can use this sort of general, there has been a breakdown of trust and confidence, because it is something which is very commonly used. Obviously, there has to be trust and confidence in the relationship between the employer and the employee. That is an implied term of the employment contract. But we have seen a number of cases which have been very critical of simply reaching for that as the reason to badge it as an SOSR reason to justify a dismissal. And we see in this case of Leach against Ofcom, which we'll come back to in subsequent slides, where Lord Justice Mummery saying that the legislation is very clear that in order to justify a dismissal, the breakdown of trust must be a substantial reason, and you can't dilute that requirement by just using the breakdown of trust as a bit of a mantra whenever you're faced with some sort of difficulties. And really, I think the lesson that we can take from that is that you can't just use the expression. You've got to be able to almost go behind it. What is it that has actually caused the breakdown in trust and confidence? Because that's the thing that you're dismissing for. It's that is the thing that you're saying amounts to the material reason for getting to the point where you're considering dismissal. So if anyone starts to use the expression to, oh, there's just been a breakdown of trust and confidence, this employee has got to go, you should really be challenging that and exploring what sits behind that. What is the factual matrix that's led to the breakdown in the relationship with the particular employee? So let's have a think about some of the situations where there might be a breakdown of trust. And the first one that quite commonly comes up are personality clashes, or just sort of general conflicts between employees. And I think the thing to be very mindful of here is that the conflict must be causing some sort of substantial disruption in the working relationships. It's not enough just to reach again for that breakdown of trust and confidence and argue employees are not getting on, we need to put an end to this, somebody's got to go. So it has to be causing substantial disruption. And the other thing that we know from some of the cases that we have seen is that there has to be a distinction drawn between the conduct or the clash, the sort of behaviours that are arising from the clash, if you like, and the actual personality issue. So you can't just dismiss somebody because they have a personality issue. And there's a case called Isaias, which is again a sort of, it's an NHS case where there was a consultant who was known to have a very difficult personality. It was how that manifested itself in their behaviours, so how they behaved with their colleagues, that was the real reason for the breakdown of trust. And you've got to take care to sort of draw that distinction before you're going to be able to rely on SOSR as the reason for dismissal. And I spoke at the beginning about the fact that identifying the reason for dismissal is only the first part of the test. You've also got to be able to show that you've acted reasonably in treating that as the reason for dismissal. And that means that you have got to have followed a reasonable process before you actually get to the point where you are actually dismissing the employee. And in an SOSR dismissal, that will often mean, or what an employment tribunal will expect to see, is that you haven't just move straight to dismissal, that you have considered, particularly where there are personality clashes or breakdowns in relationships, of whether it might be possible to think about doing things like redeployment. So could you move the employee into another team? That is the employee who may be causing the difficulties or who's the common denominator in the personality issues. Can you move them to work to another team where there might be a fresh start? Accepting that some of you, if we were doing this on a face-to-face basis, I'm sure some of you might say to me, well, that moves the problem around and then you just end up with a personality clash somewhere else. But at least considering the issue, could you change working patterns so that employees who do clash don't have to work together at the same time or in the same parts of the building? Now you could consider, whether somebody could work from home so that they're not actually coming across each other in a face-to-face way, or considering some sort of facilitation between workplace facilitation or mediation. But really what the tribunal is expecting to see in these circumstances is some sort of sensible, practical and genuine efforts to see whether an improvement can actually be effected before you just reach automatically to dismissal in these situations. I think what we are seeing, and when you read these cases, there are a couple of more recent cases, what they tend to say is, this is a very rare case, but we have seen a few of them, so I think they're becoming less rare, is that they're used in situations where there is a clash between senior people, or the situation has just become so intractable. We have seen more of those, and so they are useful. It is useful to remember that you can use an SOSR reason in these situations. So if we look at some of the cases that we have, one of them, the first one that we've got is a slightly older case, as you can see. It's only a year younger than me. Chegan against Robert Nee and Co. This was a situation which was a personality clash between the claimant and other employees. She was coming into work and talking a lot about her sex life in the office, which in 1975, or perhaps before that, was something which was causing a lot of consternation in the working environment. Her colleagues were very disapproving of that. And what had happened here was that the atmosphere in the office had just become so tense because of her frank discussions that the whole thing had become quite unbearable and untenable, and it was starting to really seriously affect their business, and she was dismissed. Obviously brought a claim for unfair dismissal. The reason relied on was this material reason, that there had been a breakdown of relationships. And the tribunal found in this case that the business was small, that there was no real alternative to dismissal. There was no option of moving her or anything like that. And actually, it had just become so disruptive to the way that the colleagues were all working together that they had no real option but to dismiss her. So that's quite an old case. We probably have some more recent cases. If we move into Perkin against St George's Healthcare, you probably heard of this one. This was a case where an executive officer was dismissed after senior colleagues had raised concerns about the abrasive manner and management style. The behaviour included making lots of unfounded accusations against colleagues, even though they were a great performer. So they couldn't have gone down any other route. This was all about relationships with colleagues. Again, dismissed, and this was found on the basis of personality clashes and breakdown in relationships. The dismissal itself was found to be procedurally unfair. There wasn't enough done to try and resolve the situation, but there was found to be a 100% contribution to the dismissal. And this was a case in which there was this distinction as well drawn between just having a difficult personality and the impact it actually then has. How do the behaviours manifest themselves and how do they impact on the working relationships? So just another example there. And then moving much more up to date, we have the case of Gallagher against Abellio ScotRail. This involved a senior manager in a business where the ScotRail were at a point in their business life that they were having to make some very difficult decisions. These two individuals had to work very closely together. It was really important because they were at this very critical juncture and difficult period for the employer's business. And various disputes had arisen. The claimant had made various complaints about her pay rises, and also some various issues that had arisen in her team. There had been a period of sickness absence as well. But all of that resulted in her falling out with her line manager. And really, as the matter progressed, it became very clear that the claimant wasn't really interested in retrieving the relationship with her line manager. She said she didn't trust her manager. she was described in the tribunal judgment, as having been truculent. And it appeared very clear from the way the evidence came out in tribunal that she had simply been unable to move forward and put matters behind her and work together with her line manager. And given where they were in this, particularly that was such a critical juncture in the business, they decided that they were going to have to dismiss the individual. And so at her annual appraisal, without any warning, she was dismissed. There was no procedure here. But the tribunal, they described it as being a very rare case where the tribunal accepted that procedures would have been futile because the conflict between the senior people were so irretrievable, they'd broken down so far and were causing such disruption at this critical juncture that using this material reason why Mrs. Gallagher could no longer be employed in that role or indeed at all was a fair reason to rely on, and the fact there hadn't been a procedure was neither here nor there in this particular case, but do exercise caution in that because, as the tribunal said, it is a rare example of that. There is another case, and I won't. I think I talk about it in one of the other slides. There has been an even more recent case called Matthews against CGI, which similarly involved someone who I don't think was quite as senior as Mrs. Gallagher, but a situation where there was just a complete breakdown of relationships between the individual employee and the line manager. The individual had gone off sick. There was a redundancy situation, which actually the claimant in that particular case, Mr. Matthews, had kind of highlighted to his employer himself. He was involved in 5G technology, and he thought that they should be coming out of some of the work that they were doing. So he kind of created a redundancy situation. In fact, he wasn't made redundant, but had various grievances against his line manager. It then became quite protracted. He wanted his line manager dismissed, and nothing would satisfy Mr. Matthews at all. The employer made quite significant steps to try and get him back to work, to get him to work with his manager, to look at working in other teams. And actually, there was nothing to be done. And ultimately, Mr. Matthews, CGI did end up dismissing Mr. Matthews using the SOSR reasons. And in that particular case, again, the tribunal was prepared to accept that actually that was an appropriate reason for dismissal, that there had been every effort made by CGI, who had not been entirely blameless at the redundancy stage, but given they hadn't been entirely blameless, they'd really sort of gone to the ends of the earth, if you like, to try and resolve the situation and get Mr. Matthews back, and they'd just been unable to retrieve the situation in any way. And the tribunal found that they weren't to be criticised in that particular case for not having offered mediation, given how intransigent Mr. Matthews actually was. So that's some examples of those kind of cases. Then we also see these cases, and I'm sure some of you have come across these, the serial griever type complaints. And in extreme cases, these you might also be able to rely on SOSR reasons for dismissal in these cases. There are some difficulties with this because sometimes people who raise lots of grievances are doing exactly that. They're raising lots of grievances which have different subject matters, and it's quite difficult to dismiss somebody for that on the basis that they are a serial griever, because at the end of the day, employers are entitled, again, another implied term of their contract, they're entitled to have redress of grievances, and you have systems in place to allow grievances to be heard, quite detailed procedures in most cases. So they're there for employees to use, and so it seems quite difficult to criticise them for doing that. But at the same time, you can also see that there comes a point where you question whether the employee really does want to continue to be employed by you if they have something to complain about every second week. So a difficult balance to have. So you just have to be a bit mindful of the fact they are allowed to raise grievances. Maybe a different story if what they are doing is raising the same grievance and in the same ilk as Mrs. Gallagher and Mr. Matthews in the CGI case that I've just talked about. If they're not prepared to be able to move on and keep re-raising the same issue but in a slightly different way, then that might get you closer to the SOSR dismissal point. I think the other things you have to be aware about is that sometimes the disruption that are caused by serial grievers can feel worse on the inside than it can look to the outside. So, for example, to an employment tribunal, who will be approaching it from the perspective of, well, you have grievance procedures, employees are entitled to raise grievances, that's all they're doing. So, yeah, sometimes it can feel a bigger thing internally than it can feel to the employment tribunal. There will also often be overlaps with other issues such as discrimination, and we'll look at that when we come on to one of the cases in this area. And also just to be mindful that obviously employees will often argue that the way in which you follow your grievance process is a breach of confidence itself, or the outcome that you arrive at is a breach of confidence. That won't be the case unless the process that you've adopted is extremely off the rails, or the outcome that's arrived at is just one that a reasonable employer couldn't have come to. So it's quite a useful reason to be able to rely on in the context of serial grievers, which I think is something which comes up a lot and is probably coming up increasingly more often. And we do have one quite good example of this. It's a case which some of you might have seen or come across, which is the Martin against Devonshire solicitor. So this was and this is the case, I made a reference on the last slide to there being an overlap sometimes with discrimination, and this is exactly one of these cases. So the solicitor in this particular case unfortunately did suffer from quite serious depressive illness and had psychotic episodes. And so some of the things that she complained about were things that she thought were happening and which happened during a psychotic episode. So they didn't in fact happen. She just thought they had. So she had raised about 8 grievances in a 7-month period, and she also made complaints around disability discrimination. Investigations were carried out into the grievances, and in most cases they were found to be completely without any merit. There was no evidence to substantiate any of them, but she continued to maintain this position. In other words, she raised really the same grievance again and again and again. She just wouldn't let it go. And ultimately, the employer found that this was having such a bad impact on working relationships and disruption to the business that it dismissed her for the breakdown of trust and confidence. And she brought a claim arguing for unfair dismissal, and also that she had been discriminated against, she had been victimised. And the tribunal were able to find in this situation that the sort of volume and content of the grievances, the fact that they were raising the same thing over and over again, and the employee was not prepared to accept the outcome of the grievances which had been investigated, meant that the employer was able to point to potentially fair reason, and that in having conducted the investigations and having dealt with the grievances, that it had followed as fair and reasonable a process as it could in order to reach at least a fair dismissal. And it also found that there hadn't been any discrimination. So that's an example we have of these sort of serial grievers cases. Reputational risk this kind of falls into the bucket of breakdown of trust and confidence. It's not uncommon for employees to do things, often things which are outside of work. That might be to commit criminal offences, or I've made a reference there to going a bit wild on social media, where if they are known to be an employee of the council and they've done these things outside of work, then it just could have an impact on your reputation as an employer. And that in itself might be difficult for you to consider as, for example, a conduct issue. But if there is a real impact on reputation, that is another reason that you might be able to use that as a material reason why you can't continue to employ the employee in the role that they're doing. And I suppose the issue in this case really is to focus in on the ability to demonstrate the potential for reputational damage. I mean, this comes up, I made a reference to the police on the slide, this comes up probably most commonly in the context of employees who commit criminal offences or do bad things outside of work, and you are fed information from external agencies, for example, the police. And I suppose the cautionary tale there is not to just accept that information uncritically. You might have to carry out your inquiry as far as you possibly can yourself, but it might well be that there's very limited amount of investigation you can do in those circumstances. It's often not really practical or open to you to be able to investigate allegations of a criminal offence, for example, that has been committed outside of work. What you might know is that if the allegations are found to be proven many, many, many months down the line, that's when the reputational damage will crystallise. And so you might have to take some steps from the moment you know about the criminal charge or the alleged criminal activity. So reputational risk is one that you can usefully rely on. And this is just one example of that. So the Leach against Ofcom case that I referred to earlier, this was an allegation that the employee had been engaged in criminal activity outside of work. Ultimately, the allegations were found to be not proven, but because the individual was in a senior role involving child protection issues, and even although the criminal offence didn't exactly relate to that, the employer just felt that this was going to be very reputationally damaging to it, given its position as a public sector employer. And it just felt that it couldn't be in a position where it waited till the outcome of the criminal trial was known before it actually dismissed, because at that point, that's when the reputational damage would really crystallise, and it would be very heavily accused of having continued to employ somebody knowing that they had engaged in such activity. So it's quite a difficult case, and the EAT recognised that, because it recognised that if the person was dismissed in circumstances where the conduct hadn't actually been established, he was protesting his innocence. So there might well be a grave injustice to him if as happened, the allegations are found ultimately to be unproven. But the real central question here is, at the very point you become aware of the allegations, what is it reasonable for you to do? What could be the reputational damage? And if you're able to articulate why that might impact on you and cause reputational damage, then it almost certainly will be a potentially fair reason to dismiss in the circumstances. And we have one other example of this. This is Mr. Lafferty against the Nuffield Health. Mr. Lafferty was a hospital porter. He had 20 years unblemished service, and his job was basically to move anaesthetised patients from and to operating theatres. He was charged for an offence which wasn't connected to work. It was completely outside of work, but he was charged with assault and intent to rape. And you can understand in those circumstances that if you were presented with those set of facts and you were aware of that allegation, that you would be very heavily criticised if in the intervening period until it goes to a criminal trial, you do nothing about it, because you've got an employee who's accused of very serious criminal offences, which if they are true, you have continued to expose your service users to a risk, essentially. And so where there was a real relationship between the things that were alleged in the criminal charges and the potential damage to the reputation of the employer, that nexus meant that it was quite easy for Nuffield Health to be able to establish both that there was a material reason to dismiss Mr. Lafferty in circumstances where it couldn't possibly have come to a view about whether the offences had happened or not. So it couldn't be a conduct issue. But they had a potentially fair reason for dismissal, and they followed a fair process to get there. Another bucket is third-party pressure. I think this is probably one which comes up. It's probably more rare. So I think what we might do, just in the interest of time, is move on from that. But if you are put under some sort of pressure not to employ or engage a particular employee in doing particular kinds of work, then the key here is to make sure that you have hopefully contractual provisions that would allow you to move them off that work and consider where else that you could put them to find them alternative work before you get to the point of dismissal. And then if we just actually move on, what I'm going to do is just move on to the process, because I think this is probably something that is obviously important for us to cover, because I mentioned right at the start, and as I've been speaking, that identifying the sort of buckets of things that might amount to an SOSR reason for dismissal is not enough in itself. You have to be able to show that you have acted reasonably in treating that as a sufficient reason for dismissal in all the circumstances of the case. And one of the things which often comes up is whether or not you have to use a fixed procedure for SOSR dismissals. Most local authorities, in my experience, do not have a procedure for conducting an SOSR dismissal. You've got grievance procedures, disciplinary procedures, all sorts of procedures, but not one for SOSR dismissals. And that's not unusual. Generally, there don't tend to be procedures for that. Does the ACAS Code of Practice apply? That's something that's very much up for debate. SOSR dismissals are not mentioned in the ACAS Code of Practice on discipline and grievance procedures. That is not to say that they don't apply at all. So we've had a couple of cases which tend to suggest actually that on balance, you're probably better to just apply a process which mirrors the ACAS Code of Practice, in that what you probably want to do is convene a formal meeting to allow the employee to respond to the situation or the reason that you're going to dismiss them, and allow them to be accompanied to that, give them their right of representation, and if you do dismiss them, also to give them a right of appeal. I think something that often goes awry when people are going through this kind of process is to try and follow broadly something that is akin to a disciplinary process, so convening a formal hearing. I think the key thing just to be careful about in those circumstances is not to badge it as a disciplinary process, because people often copy across template letters and they'll invite somebody that they're proposing to dismiss for an SOSR reason to a disciplinary meeting, and that can cause quite a lot of confusion about what is the reason you're relying on. So if you are going to rely on an SOSR reason, what you're really doing is inviting somebody to a formal meeting, the outcome of which may be a decision to dismiss them from employment. If we just move quickly on to the next slide, because I'm very conscious of time, is just some basic rules around SOSR dismissals and the procedures. I think it is very important not to filter the facts and to give the employee as much factual detail that's there in the background, which has led you to the conclusion that there's a material reason that you can't continue to employ them. To make sure that you have evidence. So if it is about difficult relationships, you can't just say, there's a difficulty in the relationship here, it's broken down. You will want some evidence about the amount of time that managers are investing. People may be raising grievances because of the personality clash, perhaps individuals going off sick, it resulting in a lack or a dip in productivity. You need evidence of that sort to put to the employee. And I would say don't worry about the label. You want to explain the reason, but you don't have to tell the employee that they're being dismissed for some other substantial reason. That's meaningless to an employee. They just need to be told that there's a good and a strong reason, a substantial reason that you just can't continue to employ them in the role. So always being able to tie it back to that solid commercial justification, if you like. And I think we've probably covered this already, but I think I've got on this slide just the sort of what the tribunal awards might be. So if you don't get to a point where you have fairly dismissed, obviously somebody may go to tribunal, and if they are successful in their claim, the awards can be quite significant, particularly where people have high pension loss if they're in the LGPS. So the compensatory awards now for unfair dismissal have gone up to just over £115,000, or 52 weeks gross pay. So it's not an insubstantial amount. So it is important for you to make sure that you have identified the reason and that you have also followed a fair procedure that's relevant to an SOSR dismissal. And where you are dismissing for those reasons, then obviously you want to dismiss with notice as well, to avoid wrongful dismissal complaints or breach of contract complaints. And finally, all I'll just say before I hand back over to Neil is that on the next slide, we've got a bit of a plug for Workbox there. So if any of you are Workbox users, there is information on there around SOSR type dismissals. And if you're not a Workbox user and you're interested in finding out more about it, then feel free to contact me after the webinar.
Okay, thanks, Lynne. We've only got a couple of minutes left, so just one very quick question. You talked a lot in the session about breakdown of relationships between employees that can amount to SOSR, where that's causing disruption to the business. What about where the conflict is around beliefs, for example, religious or gender beliefs?
Yeah, which again is another situation which we're seeing come up a lot at the moment. People are being encouraged as part of kind of inclusion and diversity strategies, and rightly so, to bring their whole selves to work. And unfortunately, what that means is they perhaps and sometimes bring more of themselves to work than everybody really, in fact, wants them to bring to work, and start to express particular beliefs that they have, which is fine. Those beliefs have to be expressed in a way which is respectful. And we are seeing, and I'm sure some of you have seen in the press, if not experienced it in your own organisations, fallouts in some cases, just where some people may hold a belief about, well, at the moment we're seeing a lot around pro-Palestinian beliefs on the opposite side of that. We've seen gender critical beliefs versus people who would argue that they are trans exclusionary and all the rest of it. So I guess what I'd say in those circumstances is that if those beliefs are being expressed in a way which is inappropriate, the conduct route might be the way to go. If they are just being expressed and it is being done in a respectful way, but nonetheless it is leading to a clash such that the employee is not able to work together, I think you just have to be careful about how you address that, because if you're going to dismiss in those circumstances, it might be quite hard to dismiss one of those people without also triggering a discrimination complaint. So you might be in a situation where you end up having to move both or dismiss both, which is not an ideal situation to be in.
I'm conscious the time has just hit 11:45, but I do just want to squeeze in one final question from one of the viewers that asks if SOSR is being used as an alternative in an employment tribunal and that procedure is found unfair, can an award be reduced on the basis that the claimant contributed to the dismissal?
Yeah, there's no reason why it can't be. It might be quite hard if it's been, for example, a conduct dismissal and you've not succeeded on that basis. It depends how the facts have come out, but if there's a recognition that there wasn't enough to dismiss them for conduct, but the employee hasn't come out smelling a roses, so to speak, it might still be in theory it should be possible depending on the facts.
Okay, good, excellent. Well, thank you very much, Lynne. I'm conscious of the time, so I will draw it to a close now. So all that remains is to thank Lynne again for her time and to thank you all for watching today. And we hope to see you at another webinar soon. Thank you very much.
Thanks, bye.